So good afternoon, everybody. We're going to give it a minute or two while everybody joins. So good day, everyone. Welcome to the Masters Conference webinar on smartphones and BYOD impact on discovery. My name is Kevin Clark, and I will be moderating this panel and fielding questions. We have three amazing panelists with us today. The first is Lauren Black. Lauren Black is an attorney with BoyarMiller and has 8 years of experience working in both state and federal court proceedings, arbitrations, mediation, contract negotiations, and informal settlement negotiations. By working in a firm environment, she's well-versed in all matters relating to business litigation, including specialized experience in labor and employment litigation, as well as contract disputes. She is a persuasive and strong advocate in and around the courtroom. She has a Juris Doctorate from Georgetown University out of Washington, D.C., and a BA from Duke University. She lives in Houston, Texas. Our second panelist is John. John is also in Houston, and he is an e-discovery and digital forensics professional with 25 years of experience assisting clients with solutions in various industries, including IT, e-discovery, consumer goods, and hospitality. He holds a BA in business, has held leadership positions in several large consulting firms, and worked with over 100 law firms and corporations. He holds several industry certifications of training and is licensed private investigator, qualified manager in the state of Texas. Our third panelist is Rick Clark, and I'm going to hand over to Rick to introduce himself and start off.
Thank you, Kevin, and thank everyone for joining, and certainly the Masters Conference for hosting us today. I'm Rick Clark. I'm also one of the co-founders of Masters, currently with Esi Analyst, also as a co-founder, and I work with attorney teams to help them review and do analysis on the modern data types. So today, we'll kick this off with really talking about probably things you've seen quite often, and that is the growth of smartphone data being a part of discoveries. We look at some of the articles out there, and they're saying by 2023, e-discovery is going to be one of the primary factors in e-discovery for investigations and analysis. Right now, smartphones account for 40% of global communications. Recently, because of this pandemic, we're seeing spikes with WhatsApp of increase of 40%, increase in activity with Zoom. What we're using today has been upwards at 1900%. So there's a lot of discovery implications down the road with these work from home environments. And lastly, on this slide, we're looking at around 18 million messages being sent every minute of every day. And the next slide even expands out a little bit further, talking about how social media posts have 3.6 million per minute, collaboration tools at 30 million, and messaging apps at 41. So it's no real surprise why these are becoming a major part of discovery. And lastly here, before I kick it over to Lauren, with this pandemic, we'll see probably a different spike. We grabbed this slide, a few months ago, and so we're going to see that, this real-time data and all of these devices and everything that's being used to communicate and log all of various data types will be, quite a bit of growth. And we're saying 175 zettabytes by 2025. So, but let's take a look at the legal obligations around this. So I'll kick this over to Lauren.
Thank you, Rick, and thanks Masters Conference for having me. I wanted to kick it off. I don't know if anyone else has watched Tiger King, but I just really wanted to say, hey, all you cool cats and kittens, just had to do it. But to Rick's point, yes, e-discovery into cell phone forensics and devices is huge right now in litigation. So as Kevin mentioned, thanks for the introduction, by the way, I do a lot of labor and employment work and contract work, and we're seeing just a multitude of cell phone discovery, and will continue to. I will also say that thanks to people like Rick and John, who you're about to hear from, cell phone discovery and cell phone data is getting a lot easier for lawyers to process. So just whereas even 2 years ago, you would get an Excel spreadsheet with text messages, it was really hard to parse through. It's getting a lot easier to unpack. So I wanted to talk a little bit about what kind of cases implicate cell phone discovery, whether courts grant it, and in particular, sort of one of the topics I wanted to go into is just for employers, what employers can do to set the landscape for potentially seeking discovery into employees' cell phones, because sometimes it becomes necessary, unfortunately. So as I said, cell phone discovery is pervasive throughout all sorts of litigation. In labor and employment cases, you've got cell phones becoming implicated when there's an overtime dispute and an employer needs to see whether the employee was specifically working during that time or whether they were engaging in personal communications. I work a lot in the space of high-level employees leaving one company to go to the next company, and there is a ton of cell phone discovery in there. Oftentimes, the former employer will want to see what the former employee was doing before they left to get some assurances that they weren't trying to steal business or take clients or take data, proprietary data. So it comes up a lot in these breach of fiduciary duty, trade secret misappropriation types of cases. But you can, as you can imagine, it's all over the place. Employment discrimination cases, catastrophic personal injury. John and I had a case not too long ago where we had to collect dozens of cell phones because there were a lot of employees on site at an incident in Louisiana. A large explosion occurred. And so those communications and cell phone activity, pictures right before the incident, where people were, who they were communicating with, and whether they were distracted at the time was all critical to that case. Also see it a lot in spicy family law cases where divorce cases, cheating, Tinder profiles galore. Cell phones obviously there are lives, there are personal lives, so they can hold a lot of spicy information that comes out in family law cases. And we're also seeing some interesting cases where cell phones come into play in the contract context, not only just in sort of what you would normally think, but also there's some interesting cases coming out of Texas, which is where I'm located, about whether contracts can be formed via email communications or via text communications. Some interesting Texas Supreme Court cases about that. Probably a whole another CLE in and of itself. But so clearly cell phones are all over the place. I'll go to the next slide. Because cell phones are so pervasive and e-discovery into cell phones is so pervasive, it plays into the whole host or sphere of e-discovery that attorneys are increasingly becoming accountable to understand. So recently, relatively recently, there was an addition to the model rules of professional conduct for attorneys. Now attorneys also have a duty, in addition to being competent in other fields of the practice, they have a duty to maintain the requisite knowledge and skill and keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So there is a duty to stay conversant in matters of technology. There's a duty to know, especially when to bring in consultants. Nobody expects anybody to have a complete knowledge of the ins and outs of e-discovery, but lawyers are really obligated ethically to understand when they need to defer to or bring in third-party vendors and experts so that they can navigate that process competently. And kind of in keeping with this model professional rules and in keeping with all these duties of competence, you think about it, there's a lot of different ways where e-discovery, cell phone discovery, can call competence into question. So just spoliation is a big problem with cell phones. Sometimes cell phones are wiped, etc. Attorneys have to know how to preserve cell phone data and other electronic data adequately. Just a lot of different contexts in which technology and keeping apprised of technology is really important to, being sure that you're, being sure that you are meeting these ethical obligations to stay competent as counsel. If you go to the next slide, a second corollary to the duty to stay competent yourself is you also have a duty to exercise as an attorney supervisory responsibilities. So if there is a younger associate under you, any attorney that's directly reporting to you, or even a vendor or an expert that's reporting to you, you have a duty to, reasonably supervise and stay apprised of those activities. You can be even held responsible for violations of the ethical rules if you are or should be aware that those rules were violated and failed to take reasonable remedial action to correct those violations. So just definitely be aware that technology comes into play not only in just practically how litigation unfolds, but also as far as just maintaining your duties to your clients and keeping in line with those professional rules. So I mentioned spoliation. Another thing just to keep aware of, and I bring these things up, they're very large topics to unpack, but just to keep in mind, ethical collections is also really important. You want to, as an attorney, make sure that your client's not trying to break into his wife's phone by guessing a password. You want to make sure a client or someone that you're supervising or collecting data from isn't misusing without people's permission, for example, shared family data. So there's a lot of things to keep in mind just as far as if you are trying to collect forensic information or electronic information, try to be sure to understand what your basis is for doing so, because if you don't have one, you might get into that shady territory. And I guess the upshot of all of that and these kind of duties to stay apprised of technology is just attend CLEs where you can. There are a lot of free ones. And there are also some really good best practices guides for e-discovery. The New York State Bar Association has a great one that's online. And then I guess thirdly on that point, keep educated by your experts. John Myers has taught me a ton on forensics. He'll speak next. But use those resources as a way to stay apprised, because really that's the best way to stay in the loop on the technological developments. Okay, so moving on, what can employers do with respect to employees' cell phones? I get this a lot. We come into these situations a lot, and we actually write at BoyarMiller a lot of employers' policies for data usage, BYOD policies, etc. So the questions come up kind of to what extent can an employer really regulate or dive into employees' cell phone and other data? And the answer is it depends, but generally speaking, employers have a pretty broad latitude when it comes to being able to monitor, collect, inspect, and keep apprised of employees' activities. Certainly they have a right to establish as a condition of employment that an employee has no privacy as to communications on the employer's network. Every non-compete or confidentiality agreement, employment agreement that I draft contains provisions about the employees being required to return devices upon termination of the employment, and also permitting those employers to search devices upon termination of the employee's employment with the employer. Said employment like 5 times in that sentence. And that also, those policies though do extend not only into just devices issued by the employer itself, but also BYOD devices. So to the extent an employee is conducting both personal and business affairs on a device that even he or she brings for himself or herself. And there's still some gray area, and there's still some exposure to discoverability into that data. So once again, kind of a whole topic in and of itself, but important to note. Okay, discovery into cell phones, do courts allow it? The answer is yes and no. So keep in mind, generally speaking, cell phones obviously are highly personal. As I said before, conduct my entire life on my phone, all my texts to my husband, all of my social media, everything is there. So there are a lot of privacy interests that surround the cell phone in discovery into cell phone. Courts are typically very careful when permitting discovery into cell phones. So when approaching these issues, just keep in mind that the general overarching rules, definitely in federal court, and then you'll see state courts essentially echoing or applying a similar version of this. But it has to be relevant for the information to be discoverable. And also in federal courts, increasingly proportionality is a huge thing that you need to be able to show to get that discovery. Proportionality has always been in the federal rules. It was added back into the primary definition of discoverability in 2015. It's kind of been hanging around, and Rule 26 just moved around a little bit. But it's become, that is a huge factor. So it's not just relevance, but it also, whatever data you're seeking from a cell phone, that intrusion has to be proportional to the benefit that you're going to get. So courts look at a lot of different factors in assessing proportionality. The importance of the issues at stake. So if you are an executive that has left a job and has allegedly accessed a bunch of data, that's a hugely crucial issue in a case. Sometimes cell phone data is a lot less important. Mounted controversy, parties' relative access to information, parties' resources, importance of the discovery. These are all factors that courts look at when assessing proportionality. I think the biggest thing to keep in mind under that list of factors is the last one, which is whether the burden or expense of the proposed discovery outweighs its likely benefit. The burden or expense with respect to cell phone discovery, courts will construe it as immense because of these privacy considerations, because it's sensitive data, and because it requires forensic processes to get. So courts will really place a lot of a lot of weight on the burden and expense in kind of trying to navigate away towards cell phone discovery, although again, it happens all the time. And then, so the next thing I'll just point to as illustrative examples, a few cases, and there are tons of cases talking about whether cell phone discovery should or should not be permitted in a given context. I looked around, kind of did a nationwide search and tried to find cases that are apples to apples to give a general sense of when cell phone discovery will and will not be permitted. So two different contexts, completely different, but give a little bit of color around when it will and will not be allowed. So car accidents. Almost every car accident case, I don't handle a bunch of these, but almost every car accident case involves allegations that the driver was distracted. So that is a commonplace, obviously, allegation in car accident cases. So courts are often looking into or being requested to permit discovery into cell phone data of the driver to see if the driver was in fact distracted, et cetera. So in that particular context, it's probably highly relevant, but it's still not always allowed. So if you take a look at two, kind of just by way of example, a couple of different cases. One case in which the court said, yes, we will allow the cell phone discovery was a case out of Florida. In that case, the plaintiff had provided very specific evidence that the driver was in fact using the cell phone at the time of the accident. So there were witnesses that said so, and there was also limited cell phone records that had already been produced to show that the driver was in fact on that cell phone at the time of the incident. The court said, okay, we'll allow it, but we're going to only allow for a very limited inspection. It's going to be 9 hours forensic expert supervised by the other side. So it was allowed, but there was backed up by very specific evidence that the additional cell phone discovery was necessary. You can contrast that with a case where the court said, no, absolutely no cell phone discovery in a similar car accident context where it was very crucial to the case and involved allegations of a distracted driver, a case out of the Pennsylvania appellate court. And these are just by way of example, but where the plaintiff or the party was not providing specific evidence that the cell phone was in fact being used when the accident occurred. It was just kind of generally saying, look, may or may not have been used. And there was factual evidence that the driver was in possession of a cell phone, but nothing specifically saying that the driver had been using it. The court did not allow the cell phone discovery, basically said that bare assertions that a driver is distracted is not enough to warrant it, given how highly intrusive cell phone discovery is. So pretty strict on levels of proof needed to get access to that data. If you move to a trade secret misappropriation case, is thematically very similar. So these cases involve, again, we handle these a lot, cases where an executive or a high-level employee leaves and is accused of taking information, going to a competitor, or going to start his or her own company in competition with a former employer. Cases where it is granted, again, it's rooted in specific testimony, in this case, out of the Pennsylvania federal court. There was specific testimony that the plaintiff, the plaintiff admitted in a deposition that he had accessed the confidential information. So there was no question that the cell phone, he admitted that he had accessed the confidential information through the cell phone. So there was no question that the cell phone was going to show very specific relevant information, but the court insisted upon a highly, extensive protective order, and also insisted that the review be conducted through a neutral third party. If you go to cases where, it's not allowed, you'll see, for example, this case that I've cited up here, out of the District Court of Colorado, the Charles Schwab case, and Charles Schwab was accusing an employee of taking information on his way out. There, the court did not allow the access to the cell phone data because the employer, Charles Schwab, was not able to put forth specific evidence that the data would in fact be relevant. They essentially just said, hey, the privacy concerns are dealt with through a protective order, we're fine, and it just was not enough to get that access. So courts are serious. They put a lot of screens up as far as getting that data, but often it's highly important and worth a fight. So I think lastly, but if you go to the next slide. So tips regarding cell phone discovery. Again, it's often highly relevant and a huge turning point in a case. So if you're trying to get that cell phone data, there's a couple of things that you can do to increase your chances. First, be sure to make sure that you exhaust all less intrusive means of getting that information. So if you can get information through an interrogatory question, you can get information through a deposition question, the court's not going to allow you to wholesale access cell phone records. Similarly, court is a lot more likely to grant you access to information parsed out of and exported from cell phones than it is going to allow you wholesale access to the device itself. So it's very infrequent that a court will say, sure, no problem, here's the cell phone, take a look at it and give it back. Typically, you're going to want to seek really narrow and really specific information from that cell phone. Second tip is just always keep critical limitations intact. You're going to want to identify custodians to the extent you want text. You want to talk about when those texts were occurring, who was receiving the text. Just narrow your discovery quest is going to up your chances of getting that data a lot. And then this is just me as a practice tip. I think I would not necessarily start with subpoenas. A lot of people want to go and immediately subpoena the cell phone provider or the telephone provider for the records. I say go straight to the source at first. I think courts are a lot more likely to provide or allow discovery if it's directly from the source. You don't have to go to a third party. Also, Verizon and other telephone providers are going to have a lot of hoops to jump through. They deal with these sorts of subpoenas routinely. They've got a process, and it's just a little bit more circuitous. So those are kind of my recommendations on how to up your chances of getting the data if you want it. Then questions, and I'm looking, okay. Apologies. All right, I have one question. Do employers have the right to inspect or image personal cell phones of their employees? And if they do, can they do it just upon the employee's departure or at any time? So I think on that, the answer is always it depends, unfortunately. And I think whether an employer is entitled to go in and access an employee's data depends a lot on that, whether that employee had a reasonable expectation of privacy over the data. So that will depend on such factors as who owns the cell phone. If it's owned by the employee only, the employee is going to have a heck of a lot of a stronger argument that that they had an expectation of privacy in that device. Courts are going to ask, does the company have a written cell phone policy? We draft these all the time. Those cell phone policies can be sweeping, but they impact whether or not an employee is going to be able to have a reasonable expectation of privacy, because some of those policies are pretty absolute and are really permissive as far as what the employer is allowed to access. So that impacts the analysis. And I think the third thing that hugely impacts the analysis of whether an employer is entitled to go in and look at an employee's personal device is just the reason they're asking for it. So if there's a credible accusation of trade secrets misappropriation, that's going to be, that's going to weigh in favor of allowing that employer to look at the information. So it's very fact specific, but it depends on privacy, reason for the access, and the employer's policies is what I would say. And with that, I think I will turn it over to John. I think we're going to, after this session is done, I see a few more questions, but after this session is done, I think we're going to round up a bunch of questions and put out some more content. But I will not take up too much time, and I will turn it over to John Myers for his section. Thank you.
Lauren, thanks. Appreciate all the thoughts and insights that you've shared with this. We've worked together for several years now, doing a lot of these collections, and it gets really interesting in terms of the requirements and everything we've had to kind of dynamically change as the industry's changed, and you're getting more and more pressure from the legal standpoint. From a forensic perception, it gets kind of interesting. The collection of smartphones and BYOD devices and tablets, really have kind of the unique challenges. There's the technical challenges of the thousands of devices, the thousands of models, the different operating system versions. Everyone talks in just terms of either Apple or Android, but the fact of the matter is within just those two realms, there are multiple versions that really are still being maintained and operating on these devices. And then the one, probably the largest challenge at the end of the day is that our cell phones are our lifelines. I cannot tell you the number of times when Lauren or myself have said, look, we'd like to get your cell phone and collect it. And the first things out of the custodian's mouth is, what? I'm going to be without my cell phone? What about text messages and phone calls? And unfortunately, inevitably, it's something that they have to deal with, that the data's out there and it needs to be collected, and they really don't have a choice, whether it be personal or business or a combination of both, depending on what the matter is. So I could sit here and I can go on all the the technical stuff on forensic collections, and there's other webinars and there's other talks about how to do that. I want to kind of keep things more on a high level from the standpoint of the perspectives of doing these collections. With just the huge proliferation of this, and as Rick pointed out earlier, just in a few short years, we're talking about potentially 150 billion devices creating data, not only on a day-to-day basis, but a minute-by-minute or a second-by-second basis. It's just, it's daunting in terms of what we have out there. And then also, as Lauren states, with regards to the legal obligations to collect this data, just it's huge to support projects in terms of what that data is and how to collect it. And then with just the different requirements, it's really critical that we look at how you collect this data, in terms of its process, the methodology. Yes, there's technology behind this that collects it, but really having the professionals out there that know how to do these collections, how to do the processing and methodologies. And one of the reasons why this is so critical is because cell phones are way more, and BYOD devices are way more volatile than a computer ever will be. And the reason being is that if you think about it, your cell phone is on just as your computer is. However, a cell phone is updating itself in the background and the foreground. It's constantly talking to cell phone towers. It's getting geolocations. It's receiving text messages. It's sending text messages. Applications are doing other things. You may have an application that is doing stock market tracking. So the data in the phone is always changing at all times. So it's way more volatile than a computer where you may get files in, get files out, or emails or whatever the case may be. When it comes down to kind of looking at the ability to, to extract and recover data, a lot of people think that, this is just simple. I can hook it up. I can just do a simple backup. I can do, pretty much whatever I want. And, why do I need to bring a professional in? Well, the reason being is sometimes you'll find that the professionals using the tools that we have access to, and then the methodologies and processes that we've either developed or followed, or some of the industry guidelines, we have a tendency to be able to find, or may be able to find more information than just a normal IT professional or a normal user might be able to find. A good case in point is in federal court recently, I testified on some data that we were able to find, and it was actually deleted data on the phone that the expert on the other side actually did not find. I think the reasoning for this was an account of processes used, methodologies, and some of the tools that were utilized. But the end result was that we actually were able to find deleted data on the device in favor of our client, which then created a financial and spoliation claims or sanctions against the other side, which were pretty heavily held down by the judge for other reasons in the case. There just seemed to be a proliferation of this and a kind of a habit of them not turning everything over in discovery hearing. But it's interesting that as we move forward on this, that the having an expert or a professional who is really familiar with this, working with people like Lauren and other attorneys, we're able to also zero in on the information that is really relevant to the case. More times than not, we get the situation, as was pointed out, that there is a lot of personal information on these phones, social media, pictures, text messages, birth dates. People have a tendency to make notes themselves on these devices, and those notes may contain passwords. So when engaging an expert or professional, what's nice is that we can actually sit there and say and discern, all right, what are we looking for? Is there a time frame? Is there information that is relevant or not relevant? Are these text messages between certain parties, or if a text message series is between somebody and their daughter or someone that's not really relevant to a case or a project? We can kind of weed some of that information out prior to giving it into the tools and the technology that allows the project teams to review it. So when you look at this stuff, it really comes down to combining all this together and working with the teams, whether it be legal or other, to review this information. So really, when we look at this, and from our experience, we find that there are traditionally and historically, there's only been a certain amount of data that has been really sought after. Typically when we've done these cases, we just want the text messages, or we want a call log. Maybe sometimes the contacts are relevant. But really what's happened, we've seen over in the last year to 18 months is additional information that really needs to be gotten. The proliferation of things like WeChat and Signal and Line and some of these other chat applications, which provide for secure chatting, not only for personal purposes, but for business purposes. We're finding that request for that kind of information is coming forth. The chats and the text messages are normal. Geolocation is interesting, or your GPS location. As Lauren pointed out in a case where they were talking about distracted drivers, we had a case here in Texas that we worked with where there was the allegations of a distracted driver. In this case, he was actually a commercial driver of a dump truck, and there was an accident. And by using the data on the phone, we actually were able to pull out some of the tower information, some of the GPS data, and was able to ascertain that really the last message that this driver did make, while he did make a text message, was actually when he was physically parked in the yard of the concrete company that he was working for, and he was not there were no text messages with a 30-minute time frame of the accident. So that actually helped them out. So as we go through this and we look at the information, it's helping the projects teams grab that information and then putting up it into the tools for ultimately for someone to review. It gets interesting because as this data points are collected, even today with some of the photos that end up on these phones, which give time, date stamps, and even some of the metadata that's related to them, it can put people at a place or a location where they say they might have been, but there's discreping or information that is contradicting to where they've been. You send a text message saying, "Oh, I'm working from home here in this work from home situation," but then there's a picture with you that contains the geolocation of you outside at the park without your mask on and not doing what you're supposed to be doing. So without getting too much into the tools and the actual core technology that does this, the one thing that we need to understand with these devices was previously we had to be physically in front of the phone to actually capture the data. The tools that we had really made it such that we physically had to have the device in our hands and spend the time to capture it, whether it be 30 minutes to as long as 10 hours. And we've seen that happen where it's taken hours upon hours. What's interesting is that now we've been able to develop other technologies, other methodologies, and processes that let us do not only a physical kind of in-person collection, but also to do remote collections where we don't have to have the device in our hand, and we can actually do it over the wire or through some other means of capturing it local to the custodian. Recently here in the last couple of weeks while we've been working from home, we've successfully actually captured numerous phones from remote locations outside of the greater Texas area. Phones out of Atlanta, phones off the West Coast and out of Los Angeles. So it's worked out quite well because it allows us to be less intrusive to the custodians, less intrusive to the devices. In some cases, there can be some cost savings to that where we're not having to travel or be on site. There's some advantages also in this era of the social distancing era where from a health perspective, we're actually protecting the custodians and even our technicians from exposing them to potentially people that may be ill or sick or where we may be a transmitter and not know it. And then the other thing that's kind of nice about this is because from a remote standpoint, if we're grabbing that data remotely, we're actually probably able to get the data into analysis quicker than if we were doing an on-site or an in-person review of this data. So when we talk about doing these collections and looking at how we do this, why is it you want to work with an expert? Well, working with the experts and the tools that we have, we can actually solidify the results probably better than just a standard IT person may, from the standpoint of being able to understand it. The other thing too is that we can attest to the methodology, what we've done. We've spent hours documenting how we do these things to make sure that it's consistent and it's right and it's defensible. And why do we want it defensible? Well, there are times, and I've worked with Lauren on this, where I've been called to write a declaration or an affidavit, or I've been put in court to actually testify in terms of finding. Case in point, I referenced earlier, being in federal court up in New York and testifying there. The other thing that's nice about working with an expert is we've got the ability to do what I'll call kind of an early device assessment. We can look at the content and the reporting, and sometimes an attorney team may say, we want just the text messages. We just want messages, and they leave it very vague. And in their mind, I know they're thinking, maybe just text messages or MMS messages. But what we'll a lot of times expose is we'll sit there and we'll advise the teams of, well, do you realize that this device has other messaging apps on it? It's running WeChat or Signal or Line or Skype or something, and they don't realize it, and they don't realize that the data is available. So we're able to give that early assessment of the device, saying, yes, we can give you the messages, or we can give you a specific data element, but we could go so far as to actually expose or show that there's additional data sources available to them that may be able to be collected. And then, being able to report upon that in a very consistent manner. And really, the reporting is more high level from the standpoint of, this is the device, this is what's out there, this is what you're looking at. So the assessment can be made, or an argument can be made back to the courts of, we need to go get more data or not. The other thing is that with working with professionals who deal with this, we're inclined to secure the data, make sure the acquisition is solid, protecting the data, being able to recover data from places on that device that people may not have thought about. Just because the tools say that there's deleted data and it's recovered some of it, sometimes that's not all of it. There's other data that may be able to be recovered. And then even, from the standpoint of, Lauren mentioned, the employment law that she works with, we've got cases where people are bringing their own devices, and we're having to do remediation of those devices, when they've moved from one employer to the next, and being able to do that focused remediation, it helps out. And, why is this important from the standpoint of, you do have your personal information on this, and you want to make sure that the people that are collecting it are protecting that just as much as they're giving it for the projects teams. So with that, let me see. I think there was a couple questions. There's a high level one here real quick that says, how can MMS and SMS messages and other data be retrieved from an iPhone after it's been factory reset by the custodian? Unfortunately, what we've found is that with both Android and iPhone devices, once they've been factory reset, for the most part, they are reset. The data is not there. We've had a couple where we've tried either the tools that we have access to. There's a couple organizations that have come out with some other ways to potentially retrieve data, but an iPhone and Android factory reset is actually worse than formatting the hard drive of your computer. The data pretty much goes away. So that it gets a little interesting because we have that question comes up and people go, oh, I want to get it. We talked about also the physical, what situations would consider a physical situation for a phone. We have a phone that we have in the lab now that had to be sent in because it looked like it wasn't powering on, and what we found out is that the device actually is powering on, but it's stuck in a state that it can't be brought out of. So there's other issues with regards to recovering data. On that note, I'm going to defer a lot of the other questions towards the end here, and then we'll be queuing these up. I want to direct the next part of this presentation to my colleagues over at Esi Analyst. Esi Analyst is a partner of ours that we work with, where we take the preserved data and the raw data that we export and then push it in their tool for analysis. And this really is great because this tool allows us to take the modern data types where we're dealing with, and to use some of the phrase I've heard them talk about, that allows us to connect the dots and kind of tell the whole story. So with that, I'm going to turn it over to Rick Clark from Esi Analyst. Rick?
Oh, thank you, John. Really appreciate it. And Lauren as well. This really sets up for, well, what do we do now when we have all of this data? So as a quick overview, the next slide, we find that there's lots of different cases that come into and through our system, and the type of litigation really impacts that and helps set the workflows around it. So as a quick overview, general litigation, there could be internal chat, collaboration, Slack, Teams, employment, and white collar could expand out to computer activity and other types of communications, and even geolocation to tell the story. So I'm going to do a quick overview of what that looks like in an analysis tool and show you what the, what that can look like and why it's really important to start including all of those data types. So I'm gonna go ahead and share my screen here. So when we look at the various data types, we categorize them to communications, computer activity, financial transactions, social media, and even geolocation. A lot of these are done through mobile collections, but what we're really finding is that if you're expanding out and collecting workstations and things off of the network, you might find other data that could be imported. For instance, communication volumes, you can see quick insights with peaks and valleys, and even what could be important are the gaps in communications, whether this is data that has not been collected, it was deleted. So quick insights into that data can be helpful. Geolocation is a part of those collections. Celebrite, Oxygen, they both have a tab that has the geolocation data in there. And then computer actions, you might have a device added, removed to the laptop or workstation, a file folder created, URLs accessed, or even data copied from something. These computer actions can be very important to help stack up with the other data to tell that story. Social media can be the same, as well as financial transactions. But to stay within scope and topical within this conversation, I have a quick example of what this might look like. So I've created the case here, Montana. We look at, as an industry, we look at emails as a document. We have our body, and metadata. We also have our images. Enron has also blessed us with some really funny, humorous type attachments. But you might also see videos and things, and these are all very important to put into a platform review those normally. Now, this just takes me back real quick to my high school days of crew, and thought you might enjoy that. Thank you again, Enron. Now, when we look at text messages, though, we're really expanding out into a different way to analyze that data. Messages are short. It's hard to create context off of an individual message. So what you might do is put together a complete thread of that data. Okay, so we have a thread here that contains all of the conversations between two particular actors. So you'll have the conversations for them over all period of time. The other could be just a 24-hour thread to bring us back to that familiar space of bubbles and pictures and really creating, again, that context around those items. So again, you can play videos, inline as well. And you can certainly bulk tag. These all could be relevant, and you're moving on to the next thread. But expanding a little bit further, we might find that the location in which that message was sent or groups of messages could be important. So we see here at 7:17, the text was sent. At 7:20, the phone registered a geolocation point. So you might look at that as well, and then you can drill in to that specific geo point of where he was when he sent that message, and Bucks T4 Lodge could be important to a particular conversation. So that's one way to look at the data, but the most important part is taking all of these elements and pulling them together to tell the story. Or you might look at using familiar type tools like most frequently contacted. So you could grab all of Bill Williams, and let's assume let's have this part of the story. He's a departed employee, and we want to find out more information on this particular individual. So we might import some of the contact list. We also can link those to those phone numbers and drill right into that message and see that conversation between those individuals and drill into those conversations. Other ways to look at this is maybe the geolocation itself, drilling into or actually just opening up the, where the person might have been. So putting in a date range or adding an actor, or just going right into the map itself and viewing some of that data. So we can go into and start viewing items, and now we see there's computer activity, as well as where he was on vacation, and you can see even where they stayed and other aspects of it. Even blowing this out to a full screen where you can see everything and put those pieces together. So really the power around this is not only the who, the what, and when, but where they were when they did this. But all of this really comes together to tell a story, right? We're really looking to pull these elements and look at a particular timeline of when something may have happened. In this instance, we look at, let's say 2-4 and for a couple days, and we now have stacked up emails, text messages, geolocation points, and even computer activity where we see a conversation of Bill Williams talking about working together with someone, meeting at Buck's T4 Lodge, asking to bring client sheets, downloading them, and also showing that he grabbed his business plan too. And we can see exactly that activity when you stack that together with him putting in a removable thumb drive, copying over his Acme Anvil's clients list, and as he promised, he grabbed his business plan too. So again, not to go too far into this, the whole point of this is leveraging all of the data sources together to tell the story. And because smartphones are great at capturing all of those points, there's now systems in place where you can put those together and do the analysis. So I'm going to transition back, as for the interest of time, go to Q&A. And so we will, let me stop my share here, go into our Q&A. And thanks again, everybody, for attending. And so we'll talk a bit more about the growing need, legal obligations, collection, analysis of data through your questions.
Excellent. Thank you, Rick. So we have a bunch of questions, and we will try to get to as many as we can. If we cannot get to the questions in this live webinar, we will follow up with the information later to all attendees via email. So let's see. So Rick, you were just going, so I have some questions for you. Who and what type of users use ESI Analyst mostly?
That is a great question. So we really focus on the forensic teams, but we also built this for lawyers and case teams for them to do the review. So we've seen really a hybrid of the forensic teams who are generally doing the analysis, now issuing logins for attorney teams to go in and do the analysis themselves. Typically training for attorneys 15, 20 minutes, they're off to the races, tagging, and then running productions. But yeah, it's really for all user types, from attorneys to forensic analysis teams.
Right. Okay. Thank you. And one second here. Next question for you, Rick. Also, what forms of productions can be exported from ESI Analyst?
I thought that was going to come up. So yeah, the easy one is we'll certainly kick out the CSV file, the same one that you would have been loading in from Oxygen, Celebrite, any of those platforms. And also, more importantly, is the HTML at the single message, and also those threads. So the threads that I was showing earlier can also be exported out into a 24-hour thread or at the individual message level.
Okay, excellent. John, question for you. Since different tools find different types of data, do you recommend that clients use just one specific tool or multiple tools, especially if it's in a highly important case?
Now, what we find is that, with all these cases, the data is always important. We don't keep one tool in our toolbox. You talk to every expert, every professional out there, they're going to have their primary tool that they go to for doing collections. For instance, some of the bigger ones out there, Cellbrite's one of the larger ones, Oxygen's one of the larger ones, XRY. There's a bunch of those tools. Are some commercial available tools that are kind of what I refer to as consumer tools that are available. But what we find is that it's really combining those tools in some cases. We'll find that we'll use one of our deep forensic tools to do the initial collections. And then when we actually get into the device, we'll use some lower level tools to do some of the analysis of the underlying databases that reside on the phone. Some they refer to as P-lists or SQLite databases. So there's really not one tool. I hate to say it.
Right. Okay. Thank you. Lauren, next question for you. Can you elaborate on the legal basis to collect and inspect a person's personal phone? Do you rely upon the consent of the individual? If they object, what recourse do you have?
Yeah, it's a really good question, and it comes up a lot in my practice. The horrible attorney adage, or litigator adage in particular, is just it depends. But it does depend a lot on the circumstances. And it depends a lot on jurisdictional specifics. So whether you're in Texas or other states will impact just the common law rules around that ability to go in and access employee cell phone data. And also it'll depend a lot on your cell phone use policy, your employment agreements with your employee and your cell phone use policy. So how robust is that? And what does that say? I will say, I wanted to mention, so I'm glad you asked this, wanted to mention just when I was covering this slide initially. So like the Texas Workforce Commission has a set of recommendations for Texas employers, basically recommended cell phone use policies and guidelines. And those are the ones that the TWC, Texas Workforce Commission, puts forth are very, very robust for the employer. So very favorable to the employer. So like for the TWC, for example, would recommend or allows for including in an employer policy that the company owns the rights to all data and files in any computer network or other information system used in the company. The company, and I think this is kind of critical, it would be this sort of policy language that would maybe open that door a little bit. Some language such as, the company reserves the right to monitor electronic mail messages, including personal, private, and instant messaging systems, as well as any and all use of the employees of the internet. So there's language. I mean, you can draft a really robust cell phone usage policy and implement it as an employer. I think Linda, I think that's the person that asked the question. Thank you for the question. I think it's just really fact specific. So you've got to have an incredibly good reason as an employer to want to access that data. I don't typically advise going down that rabbit hole unless there's a really good reason to do so. And typically you will be able to rely on employee consent to get the data in a lot of regards. I think all of the speakers referred to just how sensitive cell phone information is. I haven't collected a single cell phone and not gotten just a lot of angst and anxiety from the custodian about just the degree of sensitivity of that information. I've even just started, since I've started practicing, just going into a typical spiel about how we're going to use it and how limited the use is going to be, et cetera. Just people don't want to give up their cell phones. So I don't know if that fully answers the question, because I think there's a lot to unpack there, and I think it's hugely situational. But if you're an employer and you're seeking data off of an employee's cell phone, I would go first to the source, make sure there's a good reason to be asking the employee, but you can't ask them. If you don't get that employee consent, then it goes to factors like, what's the reason? Does the employee have the expectation of privacy? Is that expectation of privacy reasonable? And what does your policy say? So these are all questions. My email's there, lblack@BoyarMiller.com. Love to talk to any of you for any follow-ups. And I think someone mentioned this, but maybe not. I think we'll be recording a more extended Q&A for all the questions we don't get to, and releasing that at some point in the near future as well.
Right. That is a great segue into our closing. The last question is, will this be available? So the questions and answers that we have not, or the questions that we have not addressed, we will be sending that out, as well as this recording will be available to everybody that attended today, so they can have this as a resource for them. So I would like to thank the three speakers, Lauren, John, and Rick. Thank you very much for joining us on the Masters Conference. If you're interested, those of you in the audience, if you're interested in doing a webinar, please contact us at info@themastersconference.com, and we can chat. And any final words, Rick, Lauren, or John?
No, thanks everyone for joining. We really appreciate it. And again, thank you, Masters. We might even have to have an encore. I'm seeing some chats here about this could be a 3-hour session. We agree. So we put a lot in a little. We will be sending out the recording. And in doing so, we might be scheduling another sort of encore session where we make it more Q&A. We will gauge your responses there. And yeah, thanks again, everyone. Really appreciate it.
Yes, thank you, everyone. We have a lot of questions, so we will get to those in the next day or two and get back with you all. So thank you very much. Thank you, panelists, and I hope everybody has a great day.
Thank you.
Take care. Stay safe and healthy.